Okay, so I don't have a copy of Daniel's charge sheet to share with you, although if I manage to get hold of a copy of it, I will share it. For everyone, I will put it in my Patreon. I will post it as a community post so that everyone has access to it rather than hiding it behind a paywall. And for anyone who may be wondering, a content creator can't actually accidentally cancel people's memberships. The only way a content creator is going to cancel your membership is by abolishing the tier of membership that you have joined. And of course, that's going to happen for one of two reasons. I remember way back when Grizzly first of all started her channel and she started memberships, and she had a really, really high level of membership. Like, she had tiers. And the top tier was, something special, like you got a communication with her or something like that. And I think she had one person on that top tier, and it was quite expensive. And I recall that she decided to abolish that top tier. And so that person basically, their membership got cancelled, but they then rejoined on a lower tier, so it was saving them money. The other way that it can happen is if someone decides that they've set up memberships on the bottom tier, maybe a $1.99 membership or something, which I think that's possibly what mine is. I'm not sure, I haven't checked in so long. I do think mine was the bottom tier, but anyway, the only way that can happen is if they've set up memberships on the bottom tier and they decide that they want to charge more for memberships, so they abolish the bottom tier and create the next tier up. YouTube can't turn around and make you pay extra for your membership unless you've actually chosen to do so yourself. So automatically, the moment you abolish a tier for membership, all those memberships get cancelled, and it's up to those people to rejoin. If it's at a higher level, it's their choice whether they rejoin or not. But essentially, if a content creator tells you that they've accidentally deleted your membership, then basically what they've done to you is tried to change the amount that you pay for your membership without your consent, obviously. So YouTube has just basically, because they've abolished that tier, YouTube has cancelled your membership. Of course, if a channel becomes demonetised, then your membership gets cancelled also, but that's an entirely different thing. Anyway, I just thought I'd clear that up because I know that I had heard that had happened to people with another channel, so I wanted to just explain how it is possible and explain that it's not accidental. Now, moving on to Daniel's case, or cases, because they've actually got them listed as separate cases. Now, I don't know if that's just standard practice in Canada or if they have done it intentionally to make sure that at least one of these charges is going to stick. This also points to there most likely being more than one occasion when these things occurred. So I went through these charges the other day in the video that I put out, and I think by now everyone knows what they are, but I've also added here the particular criminal code for each one and the case numbers, which are of course relating precisely to Daniel's case. So I have to say the additional information that I've got based on Daniel's charge sheets gives us a clearer picture of what's going on here. So I'm going to go through that throughout this whole video. I did these as slides because in absence of a charge sheet, I thought this gives people something to screenshot if they want the information, so you don't have to sit there and write out notes. Of course, if you are a content creator and you are going to use these slides, it would be good if you could just give me credit for them. Now, all these details would have been recorded on what is called an undertaking form, and that basically outlines the charges, as you can see, conditions, details. It doesn't obviously give probable cause or anything like that. It's just the bare bones of the case. Now, each charge has been listed as having a date range between September 1st, 2024 and March 30th, 2025. However, they also appear in a chart where it has different columns, so it's got the charges, the criminal code, I think, and then the final column is the date, and the date that is listed on there is December 1st, 2024. So in terms of the discrepancy there, I think there's a few things that could be going on there. One thing, first of all, it does say that the offence occurred between the dates of 1st September and March 30th. So it could be that it is talking about multiple events, but that 1st of December may be significant in terms of that may be the one that they have the most evidence for, the one that they can actually pursue. So when it comes to charges like this, there is that burden of proof. So they have to go into this with evidence. It might be witness accounts, it might be images, medical records, etc. So they can only pursue whatever it is that they have enough evidence to satisfy their burden of proof. Now, I find this date in March to be extremely interesting because if we are to go by these dates, then it suggests that between March and May, things weren't so bad in the house. And that would make sense because we know that in March, Cindy and Wade were going to go in there with a U-Haul and take Malaya out. Things had reached the point where she wanted to get out. And they were organised. They were going to go in, they were going to collect her and the children with this U-Haul, get her out of the situation. And Malaya turned around and said, no, I don't want to go. So that, combined with these dates, suggests to me that this is all part of that DV cycle. So you have a cycle with these things where it all starts off with the love bombing, and they're Romeo. They're just the person that you think you want to live the rest of your life with because they're just so wonderful and they are so attentive and so sweet. And then you get that first instance when something happens and you convince yourself that that's a one-off. And they're so apologetic and they double down with the love bombing and everything like that. But the thing is, those instances become more frequent and become worse. I suspect that in March, there may have been a rather significant event. Something that was enough to push Malaya to be like, right, that's it, I'm getting out of here. Contacted Cindy and said, come and get me. But then Daniel became apologetic, became so sweet, and, you know, it's just the stress because of our finances, etc., etc. He probably made the usual promises that he was going to give up the rugs, he was going to try harder and stop doing whatever it was that was causing issues. He probably was like, you know, you're the best thing that's happened to me in the world, and, you know, that sort of thing. Of course, it's also possible that he may have gone down the other avenue of, if you try and leave me, I'm going to take Meadow, you're never going to get custody of her again. Because quite often people weaponise children when it comes to these sort of relationships. But I think based on this document, if we are thinking that this probably wasn't Malaya, then I would imagine that it looks like things have gotten not so good through March. Malaya was all set to go. Daniel's played nice. She's decided to stay, and then a month later, everything fell apart again. You will note that the location that has been listed for each of these charges is actually the address on Gairloch Road. And of course, we then have Daniel being arrested on January 29th. Now, I have spoken to someone who says that they will be eyes in the court for us, and hopefully they will report back to us to give us all the details that they possibly can. Obviously, there's going to be media there as well who is going to report what happens. So hopefully we should get a fairly good picture of what has gone down. In terms of what is required of Daniel, so he has to appear on March the 2nd, and that's at the Pictou County Provincial Court. At 8:30, he has to make an appearance for the purpose of identification of the Criminals Act. That's got nothing to do with the courtroom or the judge. I'll come back to that shortly. 9:30 is when he's got his mention. Presumably, this will be the standard thing where he goes into the courtroom, the charges are read to him, and he pleads guilty or not guilty. Then it's up to the judge to decide whether he is given bail or not. And the judge may decide to impose additional conditions at that point in time, and I will come back to them after discussing what his current conditions are. Okay, so there's a number of things that are conditions with him. First of all, and this is standard in these sort of cases, he must not communicate directly or indirectly with the victim. So, he can't use a go-between to send them messages or something. There is one exception listed, and that is for a specific reason, which obviously at this time can't be disclosed, and that has to occur via a third party. They also, again, can't be disclosed in terms of the location, but they are not allowed to go to a near or to a specific location. That, of course, would be a location that is connected with the victim. If they have a change of address, a change of employment, or a change of occupation, then they must notify the court, which again is standard, and they must make an appearance for the purpose of identification of Criminals Act. That is huge. That tells us a lot, and I will come back to that in a little while. Like I said, the judge might decide to add additional conditions, such as that they are not allowed to take any drugs or have any alcohol. If the prosecution can show that there is a direct correlation between usage of those things and the things that occurred, then yes, the judge probably will impose that restriction. And there could well be a requirement for regular testing. Of course, he claims that he doesn't do any of that stuff anymore, but when you look at his eyes in that last interview that he did, it seems like he's definitely still doing it. And I mean, let's be real, some of the stories that he comes out with are the sort of stories that only someone who is doing that sort of thing could come up with in their head. Now, before I start looking at the actual criminal code for the charges, I think it's probably best to first of all look at this appearance for purposes of identification of Criminals Act, because this tells us a lot in terms of his charges as well. Okay, so I put up 2 paragraphs here to talk to you about. So this is what is outlined in the Act. So the following persons may be fingerprinted or photographed or subjected to such other measurements, processes and operations having the object of identifying persons as are approved by order of the Governor in Council. I'll keep going for now. Any person who is required under these subsections or Section 515 of the Criminal Code to appear for the purposes of this Act by an appearance, notice, undertaking, summons or order because they are alleged to have committed an indictable offence or an offence punishable on summary conviction if it is an offence that could also have been prosecuted by indictment. That other bit isn't relevant. So what this means, first of all, when he rocks up on March the 2nd for that 8:30 time. That means they're going to take his fingerprints, they are going to take photos, and I would imagine that just like Australia and America, they will also take DNA. Now, what it says is this is a requirement for anyone who is charged with an indictable offence, or if the offence is punishable by a summary conviction, but it could be punished as an indictable offence. Now, I mentioned the other day in my video the difference there. Summary is obviously it's far less extreme, and of course the penalties are less than if it is classified as an indictable offence. So it's about the seriousness of the crime. Now, each one of those offences could be classified as either summary or indictable, but I think it is significant, first of all, that he does have to do this, because to me it does suggest that they are treating these offences as being serious enough to be considered indictable offences. And there's a reason for that I will come back to as we are going through the offences. But it does appear that the emphasis for this act is that it is to be getting these identifying things from people who are going to or are charged with indictable offences. Now, if you didn't watch my video the other day, I spoke about aggravating factors in terms of how the penalties for each offence will be decided. But from going through this stuff again more thoroughly, I've realised that one of the aggravating circumstances which is going to exist for all three of these charges is almost certainly going to bump them into the category of indictable offence. And that is that these have occurred in an intimate partner situation. So it's actually stated quite explicitly that when it comes to intimate partner relationships, that these charges are treated more harshly. Now, I did go through each of these charges the other day in terms of the penalties and stuff, but now we know the actual criminal code for each one. So I'm going to go through each one of them and just go through what Daniel is facing, basically. Okay, so when it comes to SA, they are guilty of an indictable offence and are liable for imprisonment for a term of not more than 10 years, or if the complainant is under the age of 16, we don't need to worry about that. If it is recorded as a summary conviction, then imprisonment is for a term of not more than 18 months. However, like I said, because this is intimate partner related, that makes it more extreme. So I think we can be pretty certain this is going to be treated as an indictable offence, meaning that he could get up to 10 years in jail just for this one charge. Now, when we go to 266, this is the assault one. If they are guilty of an indictable offence, then they're liable to imprisonment for a term not exceeding 5 years. So, ding ding, now we're up to 15 years, quite likely. Or if it's a summary conviction, then they could be looking at a period of up to 2 years. I don't know why, in terms of assault versus SA, that in terms of if it's a summary conviction, that actually you get more time for assault than you do for SA kind of offences. Again, because this has happened in an intimate partner relationship, that escalates the severity of the charges. So I think we can be sure that it is going to be an indictable offence. Now, just a few additional bits of information that I came across. First of all, it doesn't have to be physical. So in terms of assault, then if you just raise your fist threateningly, that is still, if they believe that you're about to hit them, that's assault. Likewise, if you verbally threaten to attack them, if they believe that's going to happen, that is still assault. And in terms of what the burden is for the prosecutors, they have to prove it beyond reasonable doubt, which is what I've said just before. Okay, and this is the significant thing that I think is worth being aware of. So this is special considerations when assault happens in domestic context, and this applies also to the SA charges. Domestic assault cases receive special treatment in the justice system. Police operate under zero-tolerant policies, meaning charges are almost always laid even if the complainant doesn't want to press charges. So, with Malaya basically sharing the statements with the RCMP after Lily and Jack went missing, that would have set the ball in motion. And they would have continued to investigate that. And it wasn't up to her because of this zero tolerance. Now, I'm not going to go through the understanding domestic assault penalties because basically all it is telling you is that you're looking at a higher penalty. But it says these cases are prosecuted more aggressively. Daniel is pretty much guaranteed that these are going to be prosecuted as indictable offences. And it also says here that the Crown rarely drops domestic assault charges even when complainants recant their statements. So this essentially means that even if Daniel managed to somehow get around these conditions where he's not meant to have any contact with his victim, then even if he tries to intimidate them, even if they say, right, I recant all this, then the case is going to proceed. Because obviously, like I said before, they have to have enough evidence to be able to pursue these cases, meaning that it isn't based just on a witness statement. They're going to have photographs of injuries. They're going to have statements from witnesses who may have been aware of what happened, may have seen the injuries, medical records, stuff like that. So they can proceed. For a case to reach the point where charges have been laid, then there has to be a decent amount of evidence for them to be able to get this far. Okay, and now we have the forcible confinement. Now this one is considered to be an extremely serious charge. So for an indictable offence, you are looking at a term of up to 10 years imprisonment. And again, because it is in a domestic situation, that pretty much escalates it straight up there into an indictable offence straight away. And the description for forcible confinement is everyone who, without lawful authority, confines, imprisons, or forcibly seizes another person. So, of course, pinning someone down and taking their phone off them so that they can't ring their mother because they want to leave, that is basically forcible confinement. Now, the reason that for all these three charges that it is treated as far more serious if it is a domestic situation is that we all know where these situations can go. The moment you start talking about intimate partner issues here with these three charges, then there is always that risk of these things escalating to the point where the victim loses their life. So that's why it is treated with such seriousness when it is a domestic issue. So between those three charges, Daniel is looking at potentially up to 15 years. Now, I think we can be confident that before he gets through 15 years, that charges will be laid for whatever happened to Lily and Jack. But here's the cherry on top. Here's a little thing that I came across, and in terms of for forcible confinement, if it is treated as an indictable offence, then the minimum is 4 years imprisonment. meaning if he gets convicted for forcible confinement, it's minimum. He has to go to prison. Now, I won't go through aggravating factors again because I did discuss them in my video the other day, but for each of these charges, the relationship in terms of it being intimate partner violence, or in this case, forcible confinement, that is considered an aggravating factor. Also, the physical or mental effect on the victim is considered an aggravating factor. And if this is Malaya that we're talking about, which it definitely appears to be so, given that the address is listed as Gairloch Road, then it has been said that she was undergoing treatment recently. So it certainly seems that Daniel's goose is cooked. And of course, because these are from intimate partner relationships, that means that they're not likely to be one-off events. And that's going to become an aggravating factor too, if it is something that has been ongoing. So I wanted to just share this chart with you because it just is kind of satisfying, you've got to admit. So if, when it comes to forcible confinement, if it is charged as a summary offence, then basically it could be just discharged, which is not going to happen. Suspended sentence, which is basically where he gets given a sentence but told if you behave, you don't have to do this sentence. Fine with probation, jail with probation, or a conditional sentence of some sort. But if it is indictable, then the options are jail with probation, or jail with a fine. So given that this is in a domestic situation, I think we can look at column B in terms of it's going to be indictable, and the only penalty he's looking at is jail or jail. And then there will most likely be additional consequences. I would say almost certainly, given that we have this additional aggravating factor. So that is that he will have to be on a national DNA data bank. He will be banned from owning or possessing weapons. And obviously he will be given restricted access, so he will be not allowed to visit locations frequented by the victim. Now, he probably believes that he's going to manipulate or gaslight his way out of this. But if he decided that he was just not going to turn up to court, then again, there's more penalties. So, failure to attend court. So this is for the 9:30 session. If he doesn't turn up for that, then he's guilty of an indictable offence, and he could actually face a prison term for that of up to 2 years. It could be dropped down to a summary offence, but I doubt it, given what the charges are. So what is relevant for us is point B, having appeared before a court, justice or judge fails without lawful excuse to subsequently attend court as required by the court, justice or judge. So essentially, if he doesn't show up, then he gets an FTA, failure to appear, which could be up to 2 years in jail. Okay, so this one is slightly different, and this relates to his request or his order for appearance in terms of the Identification of Criminals Act. That is separate from his appearance, his court appearance. So if he didn't turn up for that, then that is also punishable by up to 2 years in jail. It is either indictable or summary. If it's summary, then he may get just a slap on the wrist. But if it is listed as indictable, then he could get up to 2 years in jail simply for not showing up. Like I said, I would imagine Daniel's going to turn up because I think in his head, he's going to believe that He can manipulate his way out of it, he can talk his way out of it, or he can gaslight his way out of it. Now, those conditions that I read at the start of this video, such as not having any contact directly or indirectly with the victim, if he fails to comply with any of those conditions, he's also going to get into trouble for that. So again, it will be an indictable offence, and they can be liable for up to 2 years imprisonment. It could be treated as a summary offence, but again, I think given the seriousness of the charges, it may well be treated as indictable. So, given Daniel's actions over the last almost 9 months, I could imagine him trying to put pressure on Malaya. And if he does that and it can be proven, then that straight up could be a 2-year imprisonment term. Any of his conditions, for each one of those conditions that gets broken, that can be a 2-year term. So these charges are a big deal. And Daniel's going to have to snap out of his little fantasy world, stop lying, and essentially toe the line. Now, these offences could really stack up, because those things are all outlined in his undertaking. But there's actually a separate offence listed for failure to comply with an undertaking. So if he fails to do any of the things that are outlined in that undertaking, then that's 2 years on top. So he could actually, if he just screws up completely and doesn't attend court, if they wanted to, they could just slap on multiple charges here and lock him away for 6 years or more. Of course, no doubt Daniel's legal aid lawyer will make sure that he actually complies with all these things. They'll make sure that he understands that he's actually in deep duty. So in a nutshell, these are actually fairly serious offences that Daniel has been charged with. And of course, the fact that they have occurred in an intimate partner relationship makes them more severe. At the end of the day, this means his goose is cooked. These will be treated as indictable offences, in my opinion, meaning that at the very least, just from looking at the forcible confinement, then at a minimum, he's looking at 4 years in jail. But because it is treated as more severe because it's a domestic situation, he could get the maximum penalty. So between those 3 charges, he could be looking at up to 25 years. Of course, the proviso there is hopefully the Canadian system is nowhere near as toothless as the Australian system. I know they're both based on the British Westminster system, but Australia's pretty sometimes when it comes to convictions. So I'm just hoping that Canada is better than Australia. That said, I still believe that arrests are going to be made this year over what happened to Lily and Jack. So even if he gets only a couple of years from all these charges combined, but I think it would be more than that, basically before he even finishes the terms for these, he's going to have a new term slapped on him that's going to be much, much longer. Anyway, I'm going to finish it there. I hope this has offered a bit more clarification on things for people, just added a bit more details, and I have no doubt that we're going to hear even more about this in the near future. So on that note, thanks for listening. If you're new to my channel, please subscribe. Also, please hit that like button and please leave a comment below. So thank you, and I'll catch you in the next one.